All right, are you Rebecca Rideau?
Yes, ma'am.
And Ms. Rideau was previously in court, entered pleas of guilty in cause numbers 230928, 232106, 232107.
This case hits different right from the start. For theft cases, prior convictions, and no plea deal safety net. When a case is open to the court, that means the judge has full power. No negotiated mercy, no agreed sentence. That alone should tell you how risky this moment is for the defendant.
Yeah, I would just note that seems to be an aberrant practice as far as the harshness that the state is attempting to exert on this defendant. And I don't know that it stands out from the queue of other cases before this court to deserve such treatment, but it is what it is. I would just observe, first of all, as regarding the state's posture on consecutive sentences to denial of discretionary jail credit. The defense certainly has criminal history, but it's not to such an extent or degree in the circumstances the individual cases aren't such to the extreme degree that it would warrant accumulation, and certainly the denial of her jail credit is something that is problematic. I don't know exactly which jail credit the state is attempting to deny her, but obviously if she's been in pretrial detention on these cases, it seemed that she would be entitled to that jail credit without much controversy. What grounds the state would be attempting to deny that, I don't know, but of course we would argue that she should receive credit as every other defendant before this court has for the jail time credit that they've done pursuant to these cases. I would note that the pre-sentence report indicates that she does have mental health history dating back to her time in the military, where she was discharged. She had a general discharge, and that there was notations there as far as the pre-sentence report that would involve some mental health issues. I believe her to be mentally competent. Now, I, of course, wasn't her attorney when she entered the plea, but I would assume that she has been mentally competent then as well. Although, as I said, she does have mental health history. I think that plays into her present situation with the theft cases that she has. You would note in the pre-sentence report where it's indicated that she was unable to afford the mental health treatment and the pharmacological remedies that are provided through prescriptions, and that she was self-medicating and had turned to theft in an attempt to maintain funds necessary to self-medicate. She indicates in the report that her memory indeed was impaired on 3 of these offenses, and she doesn't seem to remember those. She doesn't attempt to minimize or mitigate her conduct in that regard, where she does in fact indicate that she accepts responsibility fully for her actions. But I think that that's indicative of, again, the circumstances surrounding these offenses that, of course, I guess it seems everyone in front of the court these days is finding mental health issues as something that mitigates their criminal conduct. But I do think that in this case it is well documented, going back again to her military history, that she has suffered from mental health issues.
This is where the defense is trying to humanize her. Mental health struggles, military history, self-medicating because treatment wasn't affordable. And whether you agree or not, this is a real issue in the system. People fall through the cracks, and untreated mental illness doesn't disappear just because someone gets arrested. The defense isn't denying the thefts. They're saying context matters.
I think probation is an option with the court. Obviously, these are state jails, and the court can put her on probation. And I know that the pre-sentence report, you can look at that, tends to indicate, doesn't really indicate that they're, while they're not recommending probation for Ms. Rio, they don't rule it out.
Well, let's not talk about probation.
Okay.
Yeah.
All right. I'm sorry, but there is a paragraph for.
Well, it is an option, but that's not realistic on what's going to happen today.
They were mentioning that she'd be assessed for the specialized mental health caseload.
I understand that.
And right here, the judge shuts down probation talk. That's huge. Once a judge signals that probation isn't realistic, the conversation shifts from "can you go home" to "how long are you gone?" The courtroom temperature changes instantly.
Well, I just want to say that I do apologize to the court, and I apologize to my mom. And I'll be dealing with some things like no job, but I just want to get a chance to get home and take care of my kids. I miss graduation, I miss prom, my whole senior year. I got a 5-year-old in kindergarten, and my mama got to take care of. I'm just tired. And I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I'm old. I miss my daughter's graduation. She spoke at Westbrook graduation. I was not there. I'm tired. My baby asked me why I'm the only mom. I'm not at mom's and muffins. This is embarrassing for my kids. I want to go for my kids. I just want a chance.
This is the hardest part to watch. She's not arguing law anymore. She's arguing motherhood. Missed graduations. Missed prom. A 5-year-old being raised by grandma. Whether you believe her or not, this is real pain. And moments like this force the court to balance sympathy against patterns. Emotion doesn't erase a record, but it does remind everyone there's a family attached to the sentence.
Ms. Rideau, I understand that you're asking for a chance at probation, but you've had chances at probation, and you've been given these opportunities in the past for any kind of help and treatment and all of those things, and all of those probations were revoked. And you've had 5 felony probations revoked, 2 at one time, 3 at the other time. So I understand that they were kind of clumped together, but still, after those, all for thefts, you're here for, there was a robbery that you got some time for in 21, and then you're here now on 4 more theft cases. And so, I mean, it's unfortunate and it's sad for your family, but no one put you here but yourself.
The judge's response is blunt, but it's honest. 5 felony probations revoked. Multiple chances already given. This is where the system says, we tried the soft landings. Accountability takes center stage. Judges aren't just sentencing a moment. They're sentencing a pattern.
Mr.
Judge, you
Coleman, I know what you're...
Yeah, you've essentially hit the things that I want to hit. That in addition to what I put in my sentencing memo, I won't belabor that, Judge. The only thing I would add is she says she's tired of this. I tell you who else is tired of this. It's our local store owners and business owners who are tired of people just walking in and taking what they want from them. She stole from a sporting goods store, from JCPenney, from another clothing store on a couple of occasions. They're tired of it too, Judge. Same old song. Just different defendant. I apologize. Give me another chance. I've got all these issues. In fact, I go one step further than the same old song. It's the greatest hits, Judge. It's what you hear time and time again. And I'm sure she said it back in 2011 when she got probation, in 2014 when she got probation, in 2017. Just, I apologize. Give me another chance. I've got these issues. Judge, if ever there's a case to consider denying her the discretionary jail created under the Code of Criminal Procedure, this is the case.
And it's my understanding with regard to that,
I
but
know it's kind of, it's just
Problematic.
well, I don't say it's problematic, but
I can't give the max and do that.
that's my understanding.
That's your understanding.
Yes, that's it in a nutshell, Judge. And I just say this is a case of that to be considered. And I also say this is the appropriate case to accumulate her for her sentence, Judge. She needs, in my opinion, some stronger medicine than what she's received in the past in order to impress upon her the fact that she needs to stop engaging in this kind of behavior, Judge. Thanks, that's all.
The prosecutor doesn't sugarcoat it. Calling this the greatest hits is cold, but intentional. From a state's perspective, it's not one struggling defendant. It's store owners losing again and again. This is the voice of deterrence. If consequences don't escalate, behavior doesn't change.
Here's where I am on this. I don't disagree with Mr. Coleman. I appreciate that he's gone out and tried to figure out some stronger things to do on some of these cases where we are stuck with state jail felonies. I've been very frustrated with that in the past. I don't know that this is the one to start with either necessarily, but it's not going to be out of the realm of possibility, depending on someone's criminal history, what their prior sentences were, and I don't fully disagree that this isn't one of them. I'm not going to do that this time, but I do appreciate the thought that went into this and don't necessarily disagree that there's going to be a time that this might happen, including to you if you continue to do what you've been doing for your whole life. Because if you're back in here after today on a theft, I can assure you that Mr. Coleman will remind me what he asked me to do that I didn't do. And I will on that. Do you understand? So if you want to be there for your kids, then you got to figure out something other than stealing. I'm going to find in all of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 0928, find you guilty of the state jail felony of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2106, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2107, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24, DCCR 1925, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases, I am going to run them concurrently, which means together at the same time. Part of the reason I did the 24 months is because I'm going to see that when you come back, that this is the max on a state jail felony you can get. So next time, whoever's here, if it's me or someone else, is going to see that you have progressively gotten worse, your sentences have gotten worse, and when someone like Mr. Coleman files something asking that these run consecutive or that we deny credit, that's likely to happen. I'm handing you in all four of your cases the trial court certifications. These show that these were not agreements, and so you have not waived your right to appeal. You can talk to Mr. Kimler about that. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Kimler. Good luck to you, ma'am. You can go back with the bailiff.
Here's the final balance. The judge could have stacked these sentences, but didn't. 24 months each, run concurrently. That's mercy and warning at the same time. She gets credit for time served, but the judge makes it clear. Next time, this will go worse. This sentence isn't just punishment. It's a line in the sand.